Winslow II trial jury sends bizarre note to judge during deliberations. Jurors in the Kellen Winslow II rape trial had just finished having some previous testimony read back to them Friday afternoon when the foreperson slipped a handwritten note to the bailiff on the way out of the courtroom. It contained two unusual requests that drew a seemingly incredulous reaction from Judge Blaine K. Bowman. The jurors could benefit from an explanation as to what being under oath means, the first part of the note said. Underneath was a jury on the Kellen Winslow II rape trial, now in its third full day of deliberations, sent the below note to the judge. Things might be getting. After meeting with prosecution and defense for several minutes, Bowman called jurors back into the courtroom to address the note. Calmly as he could, Bowman first told the jury that being under oath requires a witness to tell the truth, the whole truth and nothing but the truth. You heard over 30 witnesses stand before you and take that oath, the judge said. It's an oath that is a. Bowman then strongly admonished jurors that they are to follow the law as it is written and they are not to ad-lib, noting that was one of the questions on the jury selection questionnaire each of them filled out last month. Speaking of taking oaths, you all said under oath that you could follow the law as the court explains it to you even if you disagreed with the law, Bowman explained. You may not remember, we cannot have a different law being applied in any courtroom anywhere in this state just because a juror or some jurors happen to disagree with that law. Attorneys who are following the case from afar were just as flabbergasted by the foreperson's note as Bowman appeared to be. It was a very unusual jury note, Los Angeles criminal defense attorney Arash Hashimi said. Added Philip Holloway, a legal analyst and criminal attorney with the Georgia-based Holloway Law Group. I've seen a lot of bizarre jury questions, but I don't think I've ever seen anything quite like that. This ranks near the. It's difficult to say with certainty what deliberation room debate led the foreperson to pen that jury note, but Holloway believes the under oath question suggests jurors are struggling to figure out how to deal with a witness that is not to be believed. The credibility of Winslow's 5 accusers is at the core of this case. The defense attempt. It's really hard to infer from one jury note what is happening in the jury, but at a minimum we can deduce that they're struggling with witness credibility, Holloway said. Since the jury had previously asked to have the testimony of Jane Doe read back to them, it is possible the question could relate to that case. Doe testified on. The explanation for the foreperson's second question is more straightforward, according to attorneys following the case. They believe one or more. Winslow is a former NFL tight end and the son of Kellen Winslow Sr., a Hall of Famer who remains a beloved figure in the San Diego area. The younger Winslow, regardless of what charge the jurors' questions are about, Holloway and Hashimi agree that this is a good sign for the defense. Said Holloway, when there's confusion in the jury room and they don't get clarification, they'll often throw their hands up and say, well, that's reasonable doubt. More from Yahoo Sports.
Raindrop, drop top, smoking, no cooking the hot pot. Fucking on your bitch, yeah, that. Looking up, open the park pot.